My name is Sarah McKay Martin, and I'm a lawyer at Sherrod Coos LLP in Ontario, Canada. Today, I'll be sharing some important new insights on an administrative payroll policy issued by the Canada Revenue Agency, or what we call the CRA, with respect to employees with a fully remote work arrangement. Effective January 1st, 2024, the CRA implemented a new policy which sets out how an employer is to determine an employee's province of employment. When an employer pays income, such as salary, wages, or commission, province of employment determines the appropriate deductions for things such as income tax, employment insurance, Canada Pension Plan, and others. The new policy applies only to an employee who works 100% remotely under a remote work agreement. The CRA defines a remote work agreement as an agreement by which the employer either directs or allows an employee to perform their employment duties 100% remotely at a location that is not an establishment of the employer. This agreement can be either temporary or permanent. An establishment of the employer is any place or premises in Canada where employees report to work or from which employees are paid. The establishment can be owned, leased, or rented by an employer and does not need to be a permanent physical location. For example, a temporary physical location, such as a field office on a construction site or a pop-up shop for a retail store, are both considered establishments of the employer. To determine province of employment, an employer must consider whether an employee is attached to an establishment of the employer. If they are, that location is considered the employee's province of employment. With the new policy, the CRA set out primary and secondary indicators to help employers make that assessment on a case-by-case basis. The primary indicator is whether the employee would physically come to work to carry out the functions related to their employment duties at that establishment if it was not for the full-time remote work agreement. If an employee physically reported to an establishment of the employer immediately before entering into a remote work agreement, that location is the establishment to which the employee is attached. This is unless the employee's circumstances have changed or the nature of their duties have changed. Without providing an exhaustive list, the secondary indicators include consideration of the establishment where an employee attends or would attend in-person meetings, where the employee receives work-related material or equipment, the establishment responsible for or which supervises the employee, and more. If, after analyzing these factors, an employee can be reasonably considered attached to more than one establishment, the same indicators should be assessed to determine which establishment the employee is more closely attached to. Employers should note that if an employee is fully remote but does not have what the CRA considers to be a fully remote work agreement, the new policy does not apply. Instead, the province of employment will typically be the location of the establishment of the employer from which that employee is paid. Finally, another important consideration, and something very important to remember, is while the new policy provides guidance for certain CRA deductions, this is not determinative of an employee's province of employment for other purposes, such as employment standards legislation, occupational health and safety requirements, human rights legislation, and more. If you'd like more information about this, you can find my bio in the description below. Thank you so much for watching our Employment Matters vlog. Remember to subscribe for current insights and updates on important global labor and employment topics presented by the ELA.